Okay. Can you help me do it so that I can see the questions? Okay, welcome to another beautiful edition of our podcast. This is Dr. Olu Asekun here. Today is another Wednesday. Remember to join us every Wednesday, 12 p.m. Central Standard Time, to be a part of this free information session. Today, we are continuing, or maybe I should say, we are rounding up the ground of inadmissibility. We've been discussing all kinds of grounds of inadmissibilities. Um, so we are rounding them up today. We'll be discussing other grounds. There are several other grounds of inadmissibility, ranging from health ground. There could be health ground of inadmissibility. There could be. Can you remind me the other grounds that we have discussed? I know we have discussed criminal grounds of inadmissibility. How we have discussed submission of fraudulent documents. We have discussed misrepresentation. Okay, we have also discussed overstay. Yeah, so today we are just discussing the other grounds of inadmissibilities. Um, in the other grounds of inadmissibility today, we are discussing health, terrorism, national security, public charge, and prior removals. So, as we go on today, if you have questions relating to any other grounds of inadmissibility that we have not discussed, so today's session is going to be an open session. It's going to be um, an open session. What's this? Oh. So today is going to be like a free and open session. So if there is any other grounds of inadmissibility that we have not discussed before now, you are free to ask questions about it. They just brought to my attention that we should also discuss polygamists and visa abusers, student visa abusers and polygamists. Okay, those are also part of grounds of inadmissibility. So we'll be discussing everything. So, like I said, today is open session. So, if you know of any grounds of inadmissibility, ask questions about it today. Today is an opportunity to ask questions about it. If you have ever been denied visa or green card or any form of application by the US government, you can ask questions about the grounds of inadmissibility. So, but the ones that we have discussed independently, you can go back to that. But today, any other grounds that we have not previously discussed, that is what we are discussing today. And some of the grounds that has been brought to my attention, we'll be discussing health, health ground, terrorism ground, terrorism or national security ground, public charge ground, prior removals, and they have also added the student visa abusers and polygamists. They are all grounds of inadmissibility. So, if you have questions relating to any other grounds of inadmissibility that we have not discussed, you are free to send in your question. This is an open session today relating to grounds of inadmissibility. So, starting from health ground, I want to let you know that everyone applying for green card in the United States, either you are physically present in the US or you are outside the US, wherever you may be, whatever is the ground or you are using to apply, whether you are married to a US citizen, whether you have an employer petitioning for you, whether you are granted asylum, whether you self-petition, no matter what, whether you won the lottery to undergo medical test and submit medical report. This is because there are some health ground of inadmissibility. For example, HIV used to be a ground of inadmissibility, but luckily the technology relating to HIV is now curable, it is manageable. HIV in a country like the US no longer kill people except you don't follow through with the treatment. So HIV has been removed from the grounds of inadmissibility here in the United States. But there are still some other health challenges like hepatitis B, hepatitis C. Those are still grounds of inadmissibility. So if you do a medical test and it came out positive that you have this health condition, it's not directly going to be a denial. The government will still give you opportunity to do certain things. For example, if you are the spouse of a US citizen, the US government. So your sponsor will have to show evidence of health insurance, that they can provide health insurance, and the health insurance will cover you. So these are, then you will be registered with the Center for Disease Control, CDC. You have to be registered so that they monitor you and also ensure that it does not constitute a public health challenge or public health care, a scare. So you don't, they have to be sure that this thing is not it's not a communicable disease. It's not something that you will transfer to other people. It's not going to affect the public at large. So if you meet some of these conditions, you may still be approved. In fact, when HIV was still a ground of inadmissibility, I used to have clients who were actually approved after undergoing, not, they registered with CDC, Center for Disease Control. They provided evidence of health care, and they, of course, were following it up. That kind of application is not something that is going to be approved immediately. It will take time, but at the end of the day, they will approve it if the applicant meet those conditions. So it's the same thing with all health-related grounds of inadmissibilities. So if it is something that is not going to be a challenge to the public, if you or your sponsor have health care that you show that your treatment will not be a burden to the US government, and if you registered with the Center for Disease Control, at the end of the day, they may still give you the visa, but it's not guaranteed except you followed the laid down requirement. Another grounds of inadmissibility that we have not taught is terrorism. Terrorism stroke national security. Of course, that should be self-explanatory. There is no country anywhere in the world that will knowingly allow a terrorist to come to its territory. So America is no exception. So if there is evidence, if there is anything at all linking you with terrorist organization, you will be ineligible. In fact, I have a client who was granted asylum. At the time of filing the asylum, he presented his story and everything. And of course, they believed the story. He claimed to be a member of a particular organization that was fighting for independence and all of that. Yes, they believed him and they granted him the asylum. Unfortunately, when it was time to apply for green card, before between the time he was granted asylum and the time he applied for green card, because in the US, if you are granted asylum, you have to wait 1 year before you can apply for green card. So between the time he was granted asylum and the time he applied for green card, they have now determined, the government have now determined that that organization that he claimed to be a member of, they have now classified that organization as a terrorist organization. So what that means is that they refuse to approve his green card application. So terrorism being a member of a terrorist organization is a ground for of inadmissibility under the US law. So if you are connected directly or indirectly, once there is a connection with any terrorist organization, that will be a no-no. It will be a ground of inadmissibility. Now, the other one I have here is what is called public charge. Public charge simply means that you you have to show that by giving you the green card, you are not going to become a liability to the government. So what that means is that whoever is sponsoring you will have to show evidence that they have enough income to take care of it, cannot re-enter the US except certain conditions are met. Number one, for everyone who has been removed, they are barred for re-entering the US for 10 years, for a period of 10 years. So if you have been removed or deported from the US and you attempt to come back to the US in less than 10 years, then you will be inadmissible. So even if after 10 years, you still have to file what is called I-212. That is application for readmission after deportation or removal. So you still have to file that and it has to be approved before you can come back in if you have been removed. In some cases too, depending on the ground of removal, it may also involve you having to apply for a waiver, especially where the ground of removal has to do with any of the grounds of inadmissibility. Somebody who is removed based on criminal ground may have to apply for a waiver of criminal ground that can be waived. So if it's a aggravated felony, the large portion of aggravated felony offenses are not waivable. It depends on the specific circumstances. So, and it depends also on the location of the applicant. So, and it depends on the immigration status of the applicant. So, where the applicant's crime is waivable, the applicant will have to file I-601. That is a waiver of ground of inadmissibility, waiving the criminal ground. But where the criminal offense is not waivable, for example of non-waivable offenses are aggravated felony relating to a controlled substance. There's no waiver for it. If you are convicted of controlled substance, drugs, there's no waiver for it. So those are the kinds of things you have to take into consideration. The other thing is other ground of inadmissibility is of course America is a Western nation. Most Western nations do not condone polygamy. So if you are a polygamist, that is also a ground of inadmissibility. Now, let me say this, and very important. If you are a polygamist and in your home country, the law allows polygamy, that is not a ground of inadmissibility when it comes to non-immigrant visa. But it is a ground of inadmissibility when it comes to immigrant visa. Let me explain again. If you are from a country that officially allows polygamy, if you want to apply for a visiting visa to come to the US, that polygamy is not a ground of denial. It's not a ground of inadmissibility because the law in your home country allows it. So it's on that ground. However, if you want to apply for immigrant visa means that you want to live in the US permanently, then polygamy is a ground of inadmissibility, because if you are going to live in the US permanently, then you have to follow the laws of the US. You have to adopt the laws here, and the laws here does not allow polygamy. So that is when it becomes a ground of inadmissibility. On the other hand, if you are just coming here to visit, or if you are just coming here for a conference, or you are just coming here for a business, yes, you can be a polygamist for as long as your law in your country allows it. Let me give you an example. In Nigeria, for example, the law relating to marriage in Nigeria is complex. There are different types of marriages in Nigeria, about 4 types of marriages. There is what is called marriage under the Act. Marriage under the Act means that you adopted Western law by going to the registry to go and marry. So if you do that, polygamy in that situation is a crime. Even under Nigerian law, polygamy will be a crime. In fact, I can tell you authoritatively, it is a crime that is punishable by 7 years in prison under Nigerian law. However, there are other types of marriages. There is customary law, there is customary marriage. There is a Islamic marriage called nikah. There is other traditional marriage called engagement. So if you do any of these, all these other types of marriages allow polygamy, and they are valid marriage under Nigerian law. So if you have people who got married under any of these provisions, if they apply for familiar with the late MKO Abiola, it is well known that Abiola has multiple wives. Late Simbia Abiola was there. Late Kudira Abiola was there. There are other wives. And yet, Abiola used to come to the US easily, get visa, come to the US easily. It is not because he was a rich man. It is because the kind of marriage he entered into allowed polygamy. And he did not apply to be a permanent resident of the United States. So that is what makes the difference. So I think questions are coming in already. So let me start answering it. Keep the questions coming in. The first question: are there specific types of mental disorders that will make me inadmissible? Well, that is not a question I can answer because when someone, as I said earlier, everyone applying for immigrant visa, anybody applying for green card, whether inside the US or outside the US, they have to submit medical report. So it is the healthcare providers that will determine the nature of your ailment. So if there is a mental health problem, it is the healthcare provider that will state what the diagnosis is. So I cannot tell you the specific diagnosis that can disqualify you. No, it is the healthcare provider, because it is not sufficient to just say that, oh, this person has mental challenge. No, they have to state the specific mental challenge that the person has. So it is the healthcare provider that will provide that kind of information in their medical report. That is why medical reports are submitted in a sealed format. For those who do it outside the US, the report is sent directly to the embassy. For those who do it in the US, the report may be given to the applicant, but it will be in a sealed envelope. Once the envelope is opened, that report is invalid. Then you have to redo it again. The next question: I'm a former drug addict. I have a charge for drugs, but I'm now sober. Am I inadmissible for life? Well, having a charge is different from being convicted. If you are not convicted, yes, you may be admissible. But if you have been convicted and your conviction, to the best of my knowledge, if I recollect correctly, the only type of drug that is waived is I think is a single use. There's a weight. I can't recollect right now. If I recollect before the end of the before the end of the program, I will let you know. Right now, it is only if you are convicted that you become inadmissible. If you are not convicted, you are admissible. Inadmissibility only deals with conviction. They don't disqualify people based on suspicion. You have to be convicted. So that's why there is a principle that an accused person is presumed innocent until proven guilty. So when you are convicted, that is when you have been proven guilty. But if it is just on the basis of arrest, you could be the case could be thrown out, the charges could be dismissed. So arrest by itself is not a ground of inadmissibility. The next question. I was formerly part of a terrorist organization, but I have since left that organization. Would that automatically make me inadmissible? Well, if they found out that you are a member of an organization that has been determined to be a terrorist organization, it will definitely have an impact on your application. But whether it's a permanent impact, I doubt it. But it's going to cause tremendous delay in the process of your application. It's going to create extensive background check. And of course, these are the type of application that will be pending for several years. They are not just going to, because they are not going to believe you. What if you are just pretending that you are no longer a terrorist? They are not going to believe your word for it. So, but at the same time, it may not be a permanent. It may not be a permanent bar, but it would definitely. And again, even saying that you are no longer a part, are you going to publicly declare your resignation? Because you can't just tell the US government that, oh, I'm no longer a part. No, you have to take a step to openly and publicly denounce that organization. And even at that, like I said, it will definitely take time. They are not going to take your word for it, because there is a principle that once you have done something, the tendency to repeat it is very, very high. So they are not going to just believe your word for it. The next question. When I was a young child, my parents used fraudulent documents to allow me to enter the US. Is there anything that I can do to rectify the situation? This is a little complex. If your parents use this document, your parent will probably be the one that will be affected. That is one of the reasons why they don't. That's one of the reasons why they don't allow waiver for parents where the child is the qualifying relative. It is to kind of punish the parent for their actions in getting the child to do something illegal. And I also do know that depending on your age, whatever a parent do or fail to do concerning a child, if that child is under 18, it will not count. It will not affect that child's application, because they knew that the child was probably not involved. It was the parent. So it's probably going to be the parent who will suffer the consequence. But of course, you have to show evidence that this particular person is not aware of what happened and did not participate in it. Next question. One of my family members was convicted of being an international child abductor. Could that make me inadmissible? Is there a waiver that I could file counteract this? No. Well, this question is not very clear, because if your family member is the one that is convicted, that does not affect you. Immigration does not transfer offenses to people. Everybody is responsible for his or her action. So if your family member is the one that was convicted, it is only your family member who will suffer the consequence. If you are not the one convicted, you cannot be the one suffering the consequence. However, if you are involved, I can tell you, once you mention child abductor, that comes within the purview of Adam Walsh Act. That comes within the purview of Adam Walsh Act. So that's going to be a permanent bar for whoever is responsible. It's not transferable, but whoever is responsible, it will be a permanent bar to them. It will be a permanent bar. The next question. My great grandparents were affiliated with the Nazi organization and actively participated in their gatherings. Does that make me automatically inadmissible? Like I said, to the best of my knowledge, it is only the Bible that says that God always visits the iniquity of parents on their children. Immigration law does not do that. Everybody is responsible for their own action. Everybody carry their cross. So no, there is nobody who will. Everybody will carry their own cross. So even if it's your parent, it doesn't even have to be your grandparent. Even if it's your parent, the only implication is that they will scrutinize your application. Of course, there will be the presumption that you are also going to have the same tendency. So your application will be extremely scrutinized, but definitely doesn't affect it at all. So keep the questions coming in. Keep the questions coming in. Keep the questions coming in. I'm trying to see the next question. Okay, keep the questions coming in. 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 So we are discussing other grounds of inadmissibility. So keep the questions coming in. So today we are discussing other grounds of inadmissibility. All the questions that have come in, we have answered. So there are several grounds of inadmissibility when it comes to applying for green card. So we have discussed virtually all of them. So the ones that we are yet to discuss, those are the ones that we sum up today. And for today, we are discussing it in terms of general question. So if you have questions relating to grounds of inadmissibility, if you have ever been denied a visa or a green card or any form of immigration benefit, those are the things we are discussing today. We are discussing grounds of inadmissibility. Those are the things we are discussing today. So if you have questions relating to other grounds of inadmissibility that we have not treated separately, we have treated criminal grounds of inadmissibility. We have treated, can you remind me again those topics we have treated? We have discussed overstay, criminal ground of inadmissibility. We have discussed misrepresentation. We have discussed submitting fraudulent documents. So there are a lot of other grounds of inadmissibility that we have discussed. But for others that we have not discussed, that is why we are doing today. So if you have questions relating to any grounds of inadmissibility, send in your question. Send in your question. So today, other grounds that we are discussing include health grounds, terrorism related, national security related, public charge, student visa abusers, and even polygamists. So if you have any question relating to any other grounds of inadmissibility, go ahead and send in your question. Okay, I think I have a few other questions coming in. Okay, the question. I was unable to attend my hearing due to medical reasons, and I have heard that this could make me inadmissible. Is there a waiver I can file? This question is not clear enough. What kind of hearing? Is this person talking about removal proceedings? Is it talking about removal proceedings? Is it talking about a hearing relating to, I mean, hearing of what? I don't want to assume because I don't want to give misleading answers. Questions have to be very clear. So whoever sent this question, can you please clarify? So what hearing are you talking about? I was unable to attend my hearing due to medical reason. So are you talking about, are you in removal proceedings? What kind of hearing? So I really don't know how to handle this. So I can't tell you whether it will make you inadmissible or not because I don't know the hearing you are referring to. I need to know the hearing you are referring to before I will be able to answer that question. So if you can send a follow-up clarification, please, so that I can answer the question. For now, let me go to the next question. The next question, if I was ordered removed in 1993, but remain in the country that whole time, could that make me inadmissible if I try to come back into the country legally? I don't know. All these questions are not very clear because if you are ordered removed and you remain here, how can you be talking about coming back? I mean, I don't understand it. So, if you are ordered removed and you didn't go, that removal order will remain active. It's not anytime you apply for green card or apply for benefit, you are going to be denied. Again, you may even be arrested because it means that the removal order has not been executed. You may be arrested and you may be detained. You may be removed. So anytime there is a court order asking you to leave this country, so no matter how long the court order is, for as long as you are still here and you have not filed anything to reopen the case or to have the order vacated, then that order is still live. So it can be implemented at any time. Time does not affect court orders. So it doesn't matter how long. Time does not affect it. Okay, I think I have a follow-up to the previous question. I was unable to attend my hearing due to medical reasons. So the follow-up is immigration court where I was ordered removed. Okay. I was unable to attend the hearing due to medical reason, and I have heard that this could make me inadmissible. Is there a waiver I can file? Yeah, it means you have a removal order. There's no waiver about that. There's no waiver. The order is there. But the issue is, can you file a motion to reopen the case? Yes, it depends on your valid reason. And I don't even know how long this is. I don't know why you didn't file a motion immediately to explain to the court that you are not able to attend due to medical reason. So, but you can still do it if you have documentation of your medical reason. The truth of the matter is that for medical for your absence, it means that the order will have been what we call an order in absentia. So if you are ordered removed in absentia simply means that you are not in court when the order was entered against you. So if you were ordered removed in absentia, one of the good things about that is that there is no time limit for you to file your motion to reopen. So you can file the motion to reopen at any time. So if you are ordered removed in absentia, yes, you can go ahead and file your motion to reopen and provide evidence of your medical ground why you are not in court. The only challenge here is that some judges will be wondering why you didn't file the motion after you became aware that you are ordered removed. So I hope it's not too long. So it depends on the situation. But again, generally, when you are when someone is ordered removed in absentia, you can file a motion to reopen the case at any time. So for as long as you have a valid reason justifying your absence, yes, you can still do that. So the next question: why is tuberculosis considered a ground of inadmissibility? Well, I don't know the answer to that. It is only the medical professionals that will know the answer to that. But one thing I can say is that any disease that is transmissible will be a ground of inadmissibility. Any disease that is transmissible, because of public health, they don't want something that they don't want you to add more to the problem. Every country already have their problem, including the US. So if they bring somebody who just starts spreading tuberculosis to other people, that's not going to be a good public health policy. So any offense that is transmissible is going to be a ground of inadmissibility. But if it's an offense that you are the only one that will suffer the consequence, then they don't care. It's nobody's business. But if you are going to impact other people, if other people are going to get the disease because of you, yes, that is going to be a ground of inadmissibility. So I don't know. That does not affect America in any way. However, if he's living in the US as a permanent resident, I can assure you that you can be a polygamist in your country if your law allow it. If you are coming to the US on a visiting visa, yes, they will give you. It doesn't affect them. If you are coming to the US on a non-immigrant visa, yes, they will give you. It doesn't affect them. But the moment you apply for an immigrant visa simply means that you want to live in the US permanently. So if you are going to live here, you have to follow the law here. And the law here does not allow polygamy, does not allow multiple wives. So it's a ground of inadmissibility. And I can tell you that your dad in this case, he has other wives, because there is no application for green card. There is no application for immigrant visa that will not ask you questions about your spouse. And I'm sure that he only supplied the name of one wife. If he had submitted multiple names, he would have been denied. So once he has submitted the name of one of them, he can go ahead and petition for that one that he has submitted the name, but he cannot petition for the others. Actually, I've handled this type of case in the past, a long time ago in Colorado. Yes, I remember. I've handled this type of case. The man came in here listing one of the wives, and then he also came with all of his children born by all the wives. But of course, when it comes to children, they can't disqualify the children. And of course, they didn't even know that he has other wives at the time. So after he got here, he became a US citizen. He now attempted to bring in the second wife. So immigration asked for the divorce document of the marriage between him and the first wife. He responded by saying that, he was a Muslim, he didn't have to divorce the first wife, he married both of them and all of that. Of course, they denied the petition and put the woman in removal proceedings. The only saving grace I recollect, that was what saved her from being removed. Yes, it is a ground of inadmissibility. So the next question: I am physically disabled and I need to come to the US to get proper treatment. I don't have any family or anyone to sponsor me, but I really need the treatment. Is there a waiver for public charge? No. In fact, from what you have explained, you have actually indicated that you are coming to become a liability. So if you don't have a family member that will take care of you, who is going to take care of your bills? Immigration is not done on sentiment. The law is not about sentiment. So I sympathize with you, but unfortunately, that is the law. The law does not deal with sentiment. So if you don't have a family member, if you don't have anyone who will take care of the bill, they will not give you a visa. That will be a ground of inadmissibility, and there is no waiver in that regard. The only thing you can do, maybe you can look for organizations that can sponsor you, but you have to present a sponsor. Somebody has to show up as your sponsor. So there are different organizations who help disabled people. So maybe those are the organizations you have to reach out to. You can search on Google. I don't know one to refer to you, but you can search on Google. But the truth of the matter is that you have to present a sponsor in order to be admissible. The next question. I was used as a mole about 20 years ago. This was without my consent. I was caught while entering the US. I was processed and convicted for drug trafficking. Do I have a chance of getting a waiver? I doubt it. I don't think so. I mean, at the time they caught you, that is the time that you should have told them that you are acting on behalf of certain people. And I'm sure if you had cooperated at the time and they see you as a victim, you will have been eligible for what is called U visa. You will have been eligible for U visa. U visa is a victim of crime. Any victim of criminal activity, you can't come back 20 years after and say that you are used. No, you should have told them at the point that you are caught, so that you will cooperate with them, provide information, so that the person who used you will have been caught and you will have testified against that person, and that will have qualified you for what is called U visa, which is a victim of crime. So you missed that opportunity at the time. Unfortunately, there is nothing like a waiver for that. Keep the questions coming in. Keep the questions coming in. We still have about 13 more minutes. Please keep the questions. Comes to the attention of immigration that you violated your F1 status. In actual fact, excuse me, in actual fact, once you have violated your status, the law is that you are you are already out of status. That is the law. The only thing is they may not implement it against you until they found out. So if you are lucky they didn't find out, good luck. But at any time that they find out, you are already out of status. And this is not about there's no waiver about that. It's just that you are out of status. Of course, you will not be able to apply for any other thing because you have been out of status and you will be inadmissible. But of course, it doesn't stop you if you get married to a U.S. citizen. That is an immigration violation. It's not a criminal offense. So it does not make you inadmissible. Being out of status does not make you inadmissible. It simply means that you are out of status. That's it. But it does not make you inadmissible. Please keep the questions coming in. Keep the questions coming in. Keep the questions coming in. We still have about 11 minutes. Keep the questions coming in. Today we are discussing other grounds of inadmissibility. So we are discussing health ground, terrorism or national security, ground of inadmissibility. We are discussing public charge. We are discussing prior removals. We are discussing polygamists. We are discussing student visa abusers. There are so many people, because the student visa usually does not have an expiration date. It is called, it is valid for duration of status, DS. It does not have an expiration date. So because of that, people easily abuse it. However, after 9/11, of course, the government created what is known today as cervix. student and exchange visitor information system. So they created that so as to monitor those people who are actually in school and those who are not, those who are abusing it. And part of the requirement under the new system is that every school that is authorized to issue Form I-20 to international students, they must report to immigration, to ICE, Immigration and Customs Enforcement. They must report to ICE whenever a student fails to register for a semester, or whenever they become aware that the student has done one thing or the other to violate the student status. Violating the student status include working outside campus, because somebody on student status is only authorized to work on campus for a maximum of 20 hours per week. So if the school finds out that this particular student is working outside campus, they have an obligation to report to ICE immediately. If the student does not register for a semester or not register full-time, the minimum number of credit hours, they have an obligation to report to ICE immediately through the civic system. So the government has put a lot of things in place to make sure that they discover people who are abusing student status. But again, because we are discussing grounds of inadmissibility, if you violate your student status, that is not a ground of inadmissibility. That simply means that you are out of status. So whatever happens to people who are out of status will happen to you. People who are out of status can no longer change their status. They cannot change from one non-immigrant status to another. So you will not be able to do that. People who are out of status may not file employment-based application, employment-based adjustment application. So that will affect you too. So even if you graduate, if you finish your program, if an employer wants to petition for you, you will not be able to get the green card because you will be out of status. So people who are out of status will not be able to get employment-based benefit. But on the other hand, if you are out of status, it does not stop family. If you are married to a permanent resident, you will not be able to adjust your status because a permanent resident cannot petition for somebody who is out of status. Only U.S. citizen has that privilege. So if you are married to a U.S. citizen, violating your student status will not have an impact on your ability to get your green card. Keep the questions coming in. Let me see if I have any. Okay, I think I have a new question. My mother has early onset Alzheimer's and accidentally said she voted illegally during her N400 interview. She didn't actually vote, but how do I prove this? Or is there a waiver if she did vote? Actually, this can be fixed. This can be fixed because, number one, there will be record. There will be record of voters. Number two, you will need medical record. There has to be a medical record confirming that she is suffering from Alzheimer's disease. There has to be a medical record to that effect. Then there has to be an affidavit from people that are close to her, people who know her, people who, for example, people who provide, who takes care of her, the children, her colleagues, people who can testify that yes, she is suffering from this problem. And of course, there also has to be documentary evidence. Voting is something that is recorded in the US. So if you have voted, there will be record for it, especially if you use your ID, which is what every American citizen used to vote. So there will be record. So that's not something that cannot be cured. This is a problem that can be fixed. So what you just need to do is to consult with an experienced immigration attorney who can help you. This is a kind of scenario that we have handled in this office in the past. So it's not a problem. It's a problem that can be fixed. So keep the questions coming in. As I said, today we are discussing other grounds of inadmissibility, grounds like health ground, terrorism, national security, public charge, prior removal, student visa abusers, and polygamists. And of course, because today's session is open, if you have any other grounds of inadmissibility that we have not discussed, you are free to ask questions about them, because today is going to be the end of our inadmissibility series. We have been discussing inadmissibility series for several weeks. We have discussed criminal ground of inadmissibility. We have discussed misrepresentation. We have discussed several other grounds of inadmissibility. But today, we are rounding up all the grounds of inadmissibility. So that is why we are making it open. So if you have a question relating to any grounds of inadmissibility, if you have been denied a visa or denied a green card on any ground of inadmissibility, you are free to ask questions about them today, and we'll be glad to answer the questions. So keep the questions coming in. Yeah, I think I have a few questions. Next question. Will my tattoo be a problem for my immigration application? Tattoo, what has that got to do? That has nothing to tattoo in what sense? We have to clarify. The question is, will my tattoo be a problem for my immigration application? The answer is no. Tattoo does not disqualify anybody for immigration benefit. Tattoo does not disqualify anybody for immigration benefit. However, let me say this. I don't know who sent the question. I don't know what they are trying to achieve. But based on the question they ask here, will my tattoo be a problem for my immigration application? The simple answer is no. It cannot. And I'm 100% sure of that. It cannot. Because that is one of the things that makes America America. It is your choice to do whatever you want with your body. It is not a ground of inadmissibility. Having said that, let me say this. If you are applying for green card, remember, they are going to conduct extensive background check before they approve your application. So if you have a tattoo, the kind that shows that you are a member of a organization that is considered to be a terrorist organization by the American government, that will be a ground of inadmissibility. Because we are talking about terrorism, national security. So that will be a national security ground of inadmissibility if the kind of tattoo that you have is a kind of tattoo that shows that you are a member of a proscribed organization, or you are a member of a proscribed either terrorist organization or secret cult. Those can be a challenge. But the fact that you have a tattoo does not have anything to do with your immigration benefit. So I hope I've been able to clarify that. The next question. Will domestic violence conviction prevent your receiving a green card? Yes. Yes, domestic violence is a ground of inadmissibility, especially if it is a felony or aggravated felony. If it is not aggravated felony, you may be able to apply for waiver of criminal ground of inadmissibility. But if it is aggravated felony, then you are out of luck. The next question. Will legal use of marijuana make applicants for immigration benefit inadmissible? Yes. Let me tell you this. Right now, there are some states in the US that has legalized marijuana. But the truth of the matter is that it is still a federal crime. And immigration is a federal benefit. So it does not matter what your state law says. If you are convicted, it will be a ground of denial because immigration is a federal benefit. Immigration, the federal law makes it a crime as at today. The next question. Okay, this one has two parts. Part one, I applied for health insurance from the government 20 years ago before 9/11, and I lied about my legal status and I claimed to be legal permanent resident. Now my son will petition for me, but I am afraid the previous information will affect my application. Yes, it will affect your application, but your application will still be denied. It will still be approved. If you don't have any other ground of inadmissibility, your application will still be approved because the truth of the matter is that what constitutes a ground of inadmissibility is false claim to U.S. citizen, not false claim to permanent resident. It is false claim to U.S. citizen that is a ground of inadmissibility. So if your lie is that you are a permanent resident, just come out that you are not a permanent resident. That was not right. They may not even bring it up, except you yourself, except you run out of luck. But if you had falsely claimed to be a U.S. citizen, that is a problem. That one is a problem. The last question, will a green card holder with a DUI be allowed to re-enter the US? Are you talking about DUI arrest or DUI conviction? Because if you have been convicted of a felony, it doesn't matter what the conviction is, whether it's DWI, whether it's stealing, once you are convicted of a felony, if you are attempting to re-enter the US, you are at risk of being arrested and being charged for removability. And of course, depending on your situation, I'm sure there are reliefs. There are reliefs for that. A legal permanent resident can apply for 42A. That is a cancellation of removal for permanent resident. A legal permanent resident can apply for other forms of waiver. So it depends on your situation. But of course, once you have been convicted of a felony, you can be arrested at your return if you are attempting to enter the US. So I think that we are going to stop here for today. It's already 1 p.m. So we are stopping here for today. So next week is another day. Remember to call your friends, your family member, your co-workers. Remember to call all of them. And remember to subscribe to our channel so that whenever we go live, you can be notified. It is a pleasure to continue to provide this free legal service to our people. This is just to prevent people from making avoidable mistakes, avoidable errors. And we do this every Wednesday free of charge. So all you can do to show appreciation is just to ensure that you invite other people to be a part of this. So as you are enjoying the free information so that others too can do the same. Thank you so much. See you next Wednesday. Bye for now. Dr. Olu Asekun.
Because like I told you, I'm like a member of this family. And call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I announced, okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So, okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was
a big challenge. But again, we were able to put smiles in our face and we were able to get her substantial amount of money from the insurance company. Even after paying all our medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, you know, Nigerians, you know how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own. And we all celebrated. It was a good thing.